We have Miss Alvarez, Miss Peabody. Anyone else from the defense team?
Not heard any updates on them. I know Mr. Maroney and Ms. Perez may be joining us, but we don't have to.
Okay, yeah, neither one of them has logged in yet. Okay. All right, so we were discussing yesterday availabilities to start the trial. As I had indicated, I have two trials next week and the following. But I'm available March 23rd, 30th, 6th, April 6th, 13th, 20, 27. I can move anything else other than those two trials. So I can do April and I can do May.
The suite's available starting April 6th or any subsequent date thereafter,
Okay,
based upon what you just read off.
defense.
Yeah, so we discussed this yesterday. It's like we're not going to be available until the middle of May earliest. We initially said was May 18th, but because of other scheduling restrictions that the state has, I think we ultimately agreed to May 12th. My understanding is that we were, with respect to that part of it, we were on today to confirm that that worked.
And so I think, Your Honor, based upon what we had discussed with the defense's availability and looking at the month of May, what I would like to propose to the court, if that's where we're looking, is starting May 18th. I believe Your Honor has a judicial conference at the end of that week, and then starting testimony on May 26th. So jury selection and have the juror come back on the 26th.
Okay,
That works for.
okay.
That way we'd have hopefully less breaks and.
All right, so based on the defense's unavailability rest of March and April, we will set it for May 18th.
And is Your Honor finding that the defense requested a defense continuance based upon their scheduling availability and what they requested? Just in case, I mean, we are ready. But
I mean, I don't believe there is even. What we're not at sound judge. What is the defense?
There's-
for we're
Oh.
setting the date.
yes,
Right, because the court's available to restart the case, as I indicated to you all yesterday. Not these following 2 weeks, but starting March 23rd. State, were you ready for March 23rd?
the week of the 23rd is the only week the state is unavailable.
March
We are
3rd.
available any day between now, starting now.
Right, so we had March 30th,
Yes.
April 6th, 13th, 20th, 27th. Defense wasn't available any of those days. And that, so normally I would just select a date and everybody would have to be available. If you're not available, then it would be a continuance attributable to whatever side. So I can issue it for the 23rd of March, and then the state would take a continuance, then I'd move it to the 30th. And then my understanding is the defense would need a continuance for another 45 days.
Judge, we're not taking a continuance, we would object.
It's set March 30th. March 30th for trial.
Judge,
March 19th.
we're at a scheduling conference, there's no basis for taking a continuance at this point.
There is a 90-day
Window.
speedy trial window that started, and the defense came in yesterday, sorry, Your Honor. The
Yep.
defense came in yesterday and said they were not available until June
June,
3rd, which
right.
is after the 90 days.
Right,
This is why we are clarifying, and the state is ready. The only reason we are not ready the week of the 23rd is, both myself and my trial partner is.
I don't care what the reason is. I'll grant a state I think the defense said they weren't ready that week either, but I
You're
make
ready
a
every other week.
state continuance. I'll set it for March 30th. This doesn't have to be this difficult.
Well, I had no idea that we were going to be in this posture, given that none of this was discussed yesterday. I would like to confer to make sure.
Yes,
everybody is
absolutely.
able to-
I guess I assumed if you all were saying we're not ready until June and that you were going to be asking for a continuance date, because I told you all yesterday I was ready in March. And if not, I was looking at trying it in April. And that none of those dates were available to the defense. I told you that in June, there's some days I'm unavailable for about 2 weeks. So that's why we were trying to move it. I have to give you a date that's reasonable. I don't have an issue with granting a defense continuance. I'm not saying at all that I wouldn't. I would gladly grant you a continuance and set it for the date that you all were choosing, which was May 18th. I'm fine with that as well. But in order to get there, I have to give you the first available date, which is the 23rd. State's not available, so I'll grant the state continuance, and then we're at the 30th. I don't have an issue with it. Talk to your
Yeah,
co-counsels.
why don't we continue addressing you know, I can either go and speak with my co-counsel now, or we can do this after we finish with the rest of the hearing.
Go ahead and speak to them, because I think that that's probably gonna be some of the argument that you're gonna wanna use for your other motions.
All right, moment, please.
Okay. And I'll keep looking at the waiting room. I got two more family members. Avstaru? Anyone waiting for an Avstaru? Andy Sweegler? Ansari? I think I already let in. Sorry. Alnisha Fudge. A bunch of people now got out of the waiting room. Zakiria Pata, that's one that you were waiting for?
She may have gone on under. Yeah.
She, okay, they changed the name. John Weber's ESPN, he changed it. Let's see here. Ready?
Yes.
Okay,
So in order to keep the same defense team, we are going to have to go with the May 8th date. However, any defense continuance would be over our objection, given that we are within the 90-day period. Setting this, there's nothing to continue at this point. But again, because we need to keep the same defense team, May 18th is the earliest that we'll be able to do this.
well then you're not really asking for a continuance.
Well, we understand that the court is going to force us
It-
into
it's-
going.
it's
on
not
March
forced.
30th if we don't take a continuance, although we don't believe that a continuance is appropriate at this juncture, since we're talking about scheduling still within the 90-day period.
Right, when you have a speedy trial issue, it's very similar. You get, if you file a notice of expiration, it's the same thing as well. You get 10 days, but it's the court's scheduling that would would make that determination. Here, I'm telling you, I'd rather give Mr. Jones a sooner trial date than have him sit and wait. So I'm available to give him a sooner trial date. And I'm willing to give him 2 weeks from now, which I think is appropriate. It would give enough time for everybody to send notices. So that's also why the 2 weeks. I could move the trial that I have from the 16th, but then you all wouldn't have time to send notice to your witnesses. So I think the first available appropriate date would be March 23rd. If the state's not available, I'll grant the state continuance for the 23rd and set it for the following week, which is March 30th. I'll grant the defense a continuance if they want a continuance from March 30th, a continuance from April 6th, 13th, 20. I mean, the reality is you're not available for over a month and a half. Actually,
And I believe
Almost
yesterday
two.
they came in and said they were not available in March either.
right.
The only week the state is not available is the week of the 23rd. We could start next week. We could start every subsequent week.
I understand, which is why I'm putting this all on the record. If you don't want a continuance, I will leave it the 30th. It's fine. And then you guys make your strategic decision. Please discuss it with your client.
Yes, we're not available on the 30th. We're not available until May 12th. We were able to do, state's not available, we're able to do.
No, they're-
18th.
They're available.
We
Okay,
thought
May 3rd.
scheduling wise, it made more sense with breaks to start on the 18th and start.
I don't have an issue with May 12th. I'd rather sooner. So Mr. Jones is in custody. So the reality is I'm trying to facilitate the fact whenever we have a defendant in custody, we try to prioritize their cases. And so
Yeah,
that's what I'm trying to do.
My concern with that was since we couldn't start on the Monday, because Mr. Maroney couldn't start on the Monday, is we may end up having multiple breaks with the weekend and stuff. So that's why I was asking if we could start on the 18th, get a jury, and then
To be
go
honest,
straight through.
I think we're going to need a lot of days for jury selection. We may even need over a week.
Mhm.
So I don't think it's ridiculous to start May 12th and, have a good for like 8 days of jury selection. So we can start jury selection. And then if you all want to pause before you actually start the trial portion, I think that would be wise.
I guess the state's concern with that is kind of the concern we had before is once the jurors know what case they're selected for, they can be instructed not to
Right.
look up the case, but that gives them a lot more time, possible additional media coverage.
It's-
So we were just trying to kind of tighten that as much as is possible. And without,
It's up to you all. Again, I'm available in 2 weeks to start this case. The state wants a continuance for the 23rd. I'm available March 30th. Defense, you've discussed with your team. It's up to you. We can start March 30th. If you have other concerns and you want a continuance, I'll be happy to grant it. If not, I'm available March 30th going forward for the next 2 months.
Until May 12th, but the only way that we are going to be able to begin on May 12th is if the court requires us to take a defense continuance. Then we will have to take a defense continuance, but I just want the record to be clear. I don't believe that a defense continuance is appropriate under these circumstances. We're scheduling a date within the 90-day period. A speedy demand has not been filed.
No, you have a 90-day period.
I understand, but we are scheduling a date within that period. I don't believe a defense continuance is appropriate. Having said that, I understand the court's position, and if we don't have a choice, we will take a continuance in order to be able to begin with the entire team on May 12th or May 18th, whichever date is.
Okay, so we'll leave it for May 18th for the trial. That's a Monday. That gives Mr. Maroney some time to acclimate from getting back as well. So I think that's fine. Okay,
And the sounding will be 5/7.
yes. 5/7. Okay. Defense, you have a motion.
Yes, Judge. We filed a motion to modify Mr. Jones's bond. As the court is aware, he was arrested on August 19th of 2021. An Arthur hearing was held in February and March of 2022. At the end of the Arthur hearing, the court found that the state had met its burden of proof evidence presumption break and then proceeded to phase 2, and exercised its discretion, finding that bond was appropriate, given that Mr. Jones is neither a flight risk nor a danger to the community. And the court set his bond at $850,000, which through a bondsman would require an $85,000 payment. Mr. Jones obviously has not been able to afford that over the last 4.5 years, given that he is still in custody. There were 2 motions to modify bond to reduce the amount that were filed, one on April 5th, 2022, and one on June 19th, 2024. Both of those were denied. Following the trial that we just resumed on Monday, where there was a mistrial, we believe that that constitutes new circumstances for the court to consider, a change of circumstances for the court to consider in reducing his bond. So there are kind of two issues here. One is that, as the court knows, one of the factors to consider is the weight of the evidence. While the court found proof evident presumption great, that standard is supposed to be higher than proof beyond a reasonable doubt. When the state actually tried this case in front of the jury was unable to reach a conclusion, a unanimous verdict of guilty, that the state had proven its case beyond a reasonable doubt. To the contrary, my understanding is that the jury was deadlocked 5-1, 5 to acquit, 1 to convict, and the juror.
About that. Where are you basing that information from? Because I have some conflicting information. Where did you get that from?
So I spoke with a juror yesterday who.
With a juror?
With a juror, yes.
Okay, which juror?
I would rather not put this on the record, at least not in open court.
Okay.
Sidebar.
Okay,
So my understanding is that
well, let's go ahead and have you come sidebar. All right. Okay, go ahead.
so for purpose of this motion, regardless of whether the split was 5-1, 3, whatever the split was, the state was unable to meet its burden of proof and convince a jury that they had proof beyond a reasonable doubt that Mr. Jones in fact committed this crime. Based on that, I believe that the court should, first of all, reconsider the proof evident presumption great finding that it made, given that, again, that is a higher standard than proof beyond a reasonable doubt. And a jury did not find that the state met its burden of proof beyond a reasonable doubt.
Well, that would be irrelevant. I heard testimony that the jurors didn't hear, and I heard Paul Connor in person as well and made my own evaluations. But the point that I think you're trying to make is regardless of whether I found proof evident presumption great, I still, second phase, even though I should have held him no bond based on my determination that the state has met his burden, gave him a bond. So
Right, and
I
so
gave him
that's
the benefit of the
second
doubt.
part- That is the second part of what I'm talking about. So the first
Right,
part has to do with the weight of the evidence. The second part, which the weight of the evidence also informs, is that finding on phase 2, where the court decided to use its discretion, which the court has discretion,
right.
to set a bond.
Right.
However, the bond was set in an amount that Mr. Jones could not afford then and has not been able to afford since, and certainly after being in jail for 4.5 years, cannot afford now. And so, given that bond was found to be appropriate, we're asking that the court reduce that bond so that it is not de facto pretrial detention, because at this point, he functionally has no bond. He's never been able to afford that. He's not going to be able to afford that. Especially after the jury came back and a mistrial was declared. We would ask that the court reduce the bond to $50,000, an amount that Mr. Jones and his family would be able to afford, so that he be allowed,
50,000, or did he have to host 50?
no, that he would have to post 5. We're
Oh.
asking for the amount to be reduced from 800, this is in my motion, in my written motion.
I thought it was a typo. Okay, go ahead.
No, it wasn't a typo.
Okay,
$850,000 is currently his bond. I'm asking for it to be reduced to 50,000 so that he can actually post that bond and be released pending his retrial, since the state has decided to go ahead and retry him.
state, is that your, because I haven't asked you, is that your determination? Are you all going to go forward with the charges?
Yes, we are ready and we are ready for trial now. As we just indicated, there was only 1 week within the 90-day period where the state is unavailable. I do not believe that a hung jury is a change in circumstances. Your Honor has presided over this case, heard all of the evidence, as Your Honor just indicated. Further, the proof evidence presumption great in the standard ad and Arthur hearing allows for hearsay, and Your Honor has heard all the facts in the case. So what happened during juror deliberations are something that we're not privileged to know. There's no one who's come forward in front of this court. And that is the only testimony Your Honor could take, but that would be someone else's opinion of the evidence. And this is not a change in circumstance.
And I just want to put a case on the record, Nix v. McAllister. 202 Southern Second, 1, and I believe that is a first district court of appeal case, but I will verify that, from 1967. And that case stands for the proposition that following a mistrial, court must evaluate whether the evidence against the defendant meets the required standard to justify continued pretrial detention. And so while the court is not required to modify the bond amount or to change its determination as to pretrial detention following a mistrial, it is certainly something that the court should consider as a change in circumstances with respect to making that determination.
Okay, I had read your motion and with the assumption that I thought 50,000 on a homicide is basically unheard of. The reality is I still stand by my past rulings. I do understand and feel for Mr. Jones. I would like to have given Mr. Jones an answer sooner rather than later. That's why I tried to try this case for him in 2 weeks, because I know he's in custody. He's exhausted, as are the victim's family members, and everyone else that's party to this case. And I think we need to get to the end.
And Judge, I'm sorry, before you make a final ruling, I do need to take testimony from Mr. Jones.
Okay,
So,
you want him sworn in?
yes, please.
Okay,
Jones, ready? Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Right. Hi, Mr. Jones. So, I'm just gonna ask you a couple of questions. Do you have any savings that you could use to contribute to an $85,000 bond or anything close to that? Do you have any assets that you could sell in order to raise money in order to come up with that kind of money? And let me rephrase, $850,000 bond, 85,000. Do you have, and so assets, you don't have any real property, personal property you could sell?
No.
Do you have anybody in your life who could help you with coming up with that amount? Has the family tried to come up with that amount?
No.
And clearly you have not been able to do that. All right, Judge. So again, based on Mr. Jones' testimony, I just want the court to be clear that this bond is unaffordable. He cannot post it, and it is tantamount to no bond.
okay. Since we have Mr. Jones under oath, Mr. Jones, have you had an opportunity to discuss the new circumstances, the fact that the jurors have heard the case and have not been able to come to a determination? You understand that?
Yes.
Okay, right now, the state is looking to proceed with the case. Their intention is to still seek it potentially up to a maximum of life with a 25-year minimum mandatory sentence. So the minimum sentence you would be able to get is 25 years, and it could be as high as life if you are in fact found guilty. Have you discussed that with your lawyer? Now hearing that there may be people, a part of the community that would find or could find that you are in fact guilty of the offense, have you discussed with your lawyers whether or not there's any kind of a counter offer that you'd like to make, or offer that you want to make the state to resolve this matter today? Would you like to discuss that with them? Okay, you've been in for almost 5 years. I don't know what the exact amount of time is. I'm sure that you and they know. I don't know if you have any offer, but there are alternatives, especially that you have 2 months basically waiting till the next trial that could potentially get you out of custody now. I'd like you to discuss that with your lawyers and let us know so that we don't do all of this for nothing, and have you sitting in for 2 more months where there might have been a resolution that you might have been interested in. So go ahead and take a moment and speak to your attorney, and I will give you as much time as you need. Do you want, Miss Alvarez, do you want to go in the back with him since it's kind of
Yes.
very, okay, let's see if we can do that. All right, I'm gonna just pause everything and I'll step out and give you all some time to speak.
Your Honor, I believe there's some people that are in the waiting room. I've received some calls saying that they're in the waiting room.
Oh,
For
I
Mr.
only
Jones.
I have one person who just, right now, I have, a Jones who just asked to be let in. Was not there a moment ago. And then I have Eugenia Christine. Okay. Mr. Jones, have you had a chance to discuss with your lawyers? Okay, is there any offer you want to make to the state? All right, thank you. You can be seated. All right, defense, you can continue.
Well, Judge, my arguments have been laid out and they are in my motion as well.
Okay, nothing else?
There's nothing else.
All right, anything from the state?
No, nothing.
Okay, after hearing the arguments that have been made and taking into consideration the 5 years that he's been in custody, I will reduce his bond to 500,000 and set the case for the date that we chose, the 18th of May. All right,
Just for the record, Mr. Jones won't be able to afford that either.
all right.
And so, Your Honor, just since I don't want to jam this up right before trial, if we have this time, the state would be requesting a questionnaire again. I think that was helpful during jury selection. We can amend our question, try to condense it more. I think we'd put a little less than 2 pages together.
So if you'd like to make a new one and try to coordinate with the defense, why don't we do this? Let's do the 2-week date that I had suggested, March 30th.
Okay.
Okay, we'll do March 30th for a status, since I already had put the name here, okay? And at that time, we'll have a questionnaire. Now, I'm not gonna go over everybody's full voir dire, like the 10-page questionnaire or 19-page questionnaire that suggestion that I got. Let's condense it into a couple of reasonable questions that we can put together and get that out to them. I think it was very helpful, made it much shorter.
And I think that's something perhaps we could send before, and then, when their jurors that we see from the questionnaire shouldn't be on the case, they can be released for a different case. And
I agree. We do it all the time, especially on death cases. So, all right, then I'll see you.
At sounding on May 7th, should we also address the motions in limine at that point?
If there's new motions in limine that you want to file, yes.
Okay.
But let's do this. Get them to me, because I've had this issue come up before. So the sounding is going to be, what do we say, the 7th?
5/7 and 5/8.
Okay, so then let's have all motions in limine by April 27th. Motions in limine due. I'll be specific, 5 p.m. Rashaun Jones on the 27th. Okay,
thank you. Thank you.
all right.
Judge, I'm still thinking we want-
No. Just for this. All right, thank you everyone on the Zoom.